Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information about the topic that we're going to be discussing today, or for that matter, anything else in the world of or germane to the consumer finance industry, don't forget about our blog, which also goes by the name of consumerfinancemonitor.com. We've hosted the blog since July of 2011, on the very same day that the Consumer Financial Protection Bureau became operational. So there is a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. To subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know. You can leave us a review on whatever platform you may be using, Apple Podcasts, YouTube, Spotify, etc. Also, please let us know if you have ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. So let me tell you about what we're going to be talking about today. And this is a topic that we have blogged about quite a bit. And we actually, on July 10th, released a podcast show related to the same topic, although you'll see as we go through our program today, the emphasis is going to be quite a bit different than the podcasts that we recorded on July 10th. We're going to be talking about the so-called unitary executive theory, which is, in short, a theory certainly promoted by the current Trump administration, that President Trump has got essentially complete control over the so-called independent federal agencies like the Federal Trade Commission and many other agencies. That has led to President Trump, I guess I could say, flexing his muscles, and he's done it by embarking on firing Democratic members of the governing bodies of several federal agencies, including the NLRB and the Federal Trade Commission. And there are many others where he's done the same thing, so that those agencies right now are governed completely by Republicans, despite the fact that it was the intent of Congress that many of these agencies be governed by a bipartisan board or commission, where the majority party would have majority control of the governing body, but the minority party would have representation. And that is no longer the case. So let me introduce my very special guest, and that is Lev Menand. Lev is an associate professor of law at Columbia Law School, where he directs the project on public economic law. He teaches financial institutions and administrative law. He's written extensively on both subjects, including a book on the Federal Reserve called The Fed Unbound: Central Banking in a Time of Crisis. In 2022, Lev, along with three co-authors, released a new casebook on the law of networks, platforms, and utilities, the first in the field in over 20 years. Prior to joining the faculty, Lev served as senior advisor to the Deputy Secretary of the Treasury and senior advisor to the Assistant Secretary for Financial Institutions. He was previously an economist at the Federal Reserve Bank of New York in the Supervision Group, where he was part of the Governance and Culture Reform Initiative. And he was also in its Research and Statistics Group, where he helped develop econometric models for the Federal Reserve System's first comprehensive capital assessment and review. While at the New York Fed, Lev was seconded to the Financial Stability Oversight Council, FSOC, for those of you in the know, where he helped to prepare the council's first financial stability report. Earlier in his career, he clerked for Judge Rakoff on the U.S. District Court for the Southern District of New York and Chief Judge Katzman on the U.S. Court of Appeals for the Second Circuit. And he got his undergraduate degree at Harvard and his law degree at Yale. Well, first of all, Lev, a very warm welcome to you. Really delighted to have you on the program today because, of this the expertise that you have, among other things, on the unitary executive theory and what has been going on with the firings that have taken place. So, again, a warm welcome.
Thank you so much. It's a pleasure to be here.
Okay. I want to mention also, I have a lot of questions I want to get into, but I want to mention two articles that you have written, which I want to commend to our listeners. They are working drafts. They've not been published yet in a law review. They're on SSRN, which is an online repository of articles submitted in all kinds of disciplines related to all kinds of subjects. The first one is called The Supreme Court's Fed Carve-Out, an Initial Assessment. And the second one is called The Federal Reserve Board and the FOMC Are Government Regulators, Not Banks, a reply to Baud, Bamzai, and Nielsen. There are three other professors who have written articles that apparently disagree with Lev about that. Both of these articles are, I think, very important, and I commend to your reading. So let's start by building a little bit of the foundation for our discussion, Lev, and then we'll get into some of the more, I'm not going to call it esoteric, that's not what it is, but some of these issues involving why the Federal Reserve Board is really front and center with respect to this implementation of the unitary executive theory by President Trump. So why don't you tell us, I mentioned how Trump's early in his term started embarking on firing all these Democratic members of federal agencies. One case involving the NLRB and another agency called the Wilcox case actually made it to the Supreme Court in a very short period of time. So why don't you lay that foundation and then we'll move on from there.
Yeah, great. So since taking office, President Trump has asserted a sort of unprecedented array of powers over what you might loosely call the administrative state. There are powers to sort of direct how agencies write rules, how agencies interpret statutes. And one of the powers that this administration has asserted is the power to ignore statutes that limit the president's removal authority, that grants certain agency heads tenure in office for a term of years that can be abrogated only for cause, for things like neglect of duty or malfeasance in office, where there's notice and an opportunity for a hearing, and that can be challenged on the evidence, on the merits. And what this president has done is come in and ignored those statutes and purported to terminate a variety of officials at will, without cause, claiming that the Constitution gives him the authority to do this, that those statutes are constitutionally invalid. And several of these firings, illegal firings, have given rise to lawsuits. And what you were mentioning is the sort of marquee suit, the Wilcox suit, involving a member of the National Labor Relations Board. And that suit proceeded all the way through to final judgment at the district court, where Wilcox won an injunction reinstating her in office. Because, of course, there is precedent of the Supreme Court on all fours saying that Congress can constitutionally limit the president's removal power from multi-member commission heads. And that's the famous Humphries Executor case, decided by the court unanimously in 1935 in connection with President Roosevelt's at-will termination of a Federal Trade Commission member, notwithstanding the statute's removal limits. So the district court, of course, followed binding precedent and reinstated Wilcox. And this is what gave rise to a series of emergency applications by the government, by the Trump administration, to stay the judgment pending appeal. And so the government appealed to the D.C. Circuit and also tried to stay the judgment. And it was on an emergency application to the Supreme Court to stay the judgment that we got this order in May by the Supreme Court. The justices were divided, but a majority of the justices granted the stay, which took Wilcox out of her job, right? It nullified the district court injunction, putting Wilcox back in. So it gave Trump a lot of what he wanted. She's out of her job while the government tries to overturn the district court ruling on appeal. And so in the meantime, she's going to be out of her job. And it's in this very short ruling that the Supreme Court seems to be tipping its hand about where it's going to come out when the case, or when one of these cases, reaches the court on the merits, on the whole question of whether Humphries Executor is still good law, whether independent agencies, which are a foundation of the administrative state that have existed for a century or more, in fact have been unconstitutional the whole time, and whether or not the Federal Reserve and central bank independence, which has become a bedrock of global economic governance, is in fact unconstitutional as well within the United States. So all these questions are now up for grabs, and everyone's sort of trying to figure out what's going to happen next year. And the Supreme Court said two things that are really significant. One is that the president was likely to succeed in his challenge to the NLRA, the NLRB's Enabling Act, because the NLRB exercises executive power, which suggests Humphries Executor is going to be overruled. And the other thing that the Supreme Court said in this short order is that it doesn't think that whatever resolution there's going to be in the NLRB case applies to the Fed, because the Fed is a unique quasi-private entity with a distinct historical tradition dating back to the Bank of the United States.
Yeah, let me just pause for a second there, and then I want to, I'm looking forward to hearing the rest of the story and the concern that you have. But didn't you find it strange that in the context of this emergency docket that this case was on, there was no petition, a petition for certiorari, where things get fully briefed and, there's really a lot of care is given to cases that are on that docket. You may agree or not agree with the majority opinion in many cases, but it just seems strange to me that in this context, procedural context, they would insert such an important dictum. Do you think it suggests that they're being defensive about this issue, that they want to just nip it in the bud? I mean, it's very strange to me. It almost made me think of that I'm trying to think is that it's from Shakespeare, he doth protest too much.
The whole thing is strange, Alan, I have to say. And the strange is maybe even like too nice of a word for it, too antiseptic. I think what's unfortunately happening here is the Supreme Court is sacrificing rule of law values in order to accommodate the Trump administration. And so the main thrust of the Wilcox order is granting this emergency application that is basically overturning a bedrock Supreme Court precedent without any stare decisis analysis. That is very strange. You just don't see bedrock precedent, which basically the court needs an extremely high bar to overturn, and I just don't see how it could possibly be met on traditional legal principles, rule of law principles, to overturn Humphries Executor. Here they are granting a stay, saying, district court, we're staying your judgment because you just followed the law. You just followed the precedent that's been in place for 100 years. The president of the United States is on all fours, is ignoring this precedent, and we're going to let him do it?
I have heard the argument by some people, Lev, that the FTC in 1935, which I think was the date of the Supreme Court opinion, had powers that were significantly different than the powers that it has today. And I don't think that in this order that got issued on May 22nd, I don't think the Supreme Court got into that at all. But I have heard that argument.
Yeah, so there's a number of issues with that argument. I think it's an important one to be aware of and to have a sense about the contours of it. The FTC's powers have certainly been expanded subsequent to 1935, Magnus and Moss in 1975, FTC Improvement Act of 1980 has added civil money penalty authority, various new forms of enforcement authority. But I don't think any justice on the court wants to hang their hat on that. And I wouldn't expect that to be what is dispositive, because the FTC had both rulemaking and adjudicatory authority in 1935. And the way this court conceptualizes those authorities is as quintessential executive power. And so why does it matter that the FTC's got additional rulemaking, additional fine power, when the court has already said that rulemaking and adjudication, this is an enforcement agency, the FTC. And so there's that problem with the argument that, that's not the same as the current FTC. It's true. And you could imagine a jurisprudence that said the 1935 FTC is okay, but, the CFPB is not okay, which is sort of what Saylor law suggested. This agency is way more powerful than FTC 1935. And we would call that sort of assessment functionalism, where you look at the agency and all of its powers and how it operates in practice, and you determine whether that threatens constitutional separation of powers values by disrupting checks and balances. Functionalism is the approach to separation of powers that the Roberts Court has rejected and, in fact, ridiculed. And many people in the conservative legal movement have spent the better part of 30, 40 years trying to get rid of, in favor of their approach, which is formalism, which is like a bright line rule. If you have executive power, then X. If you don't, then Y. And under that framework, you can't distinguish between FTC and CFPB, between one office and another office. And so I don't see the court as ending there, as sensible as it would be, because functionalism is far more sensible approach to constitutional separation of powers than formalism. This is a formalist separation of powers court. Second point I would make on this, and then we can turn back to the Fed or wherever you want to steer, is that Humphries Executor was not the Supreme Court's last word on the constitutionality of limits on the president's removal power. And so it's not just Humphries Executor, some quote unquote old case, that it might be overturned. Humphries Executor's principles were reestablished repeatedly by the court in subsequent litigation, most importantly, a case called Morrison v. Olson in the late 1980s, which involved a special prosecutor in the Justice Department who could not be removed except for cause. And 8-1, with Justice Scalia in the sole dissent, Justice Rehnquist writing for the majority, the Supreme Court upheld the arrangement, saying there's nothing wrong with limits on the president's power to remove officers for cause, as long as they don't trench on the president's enumerated constitutional powers. And here, where the president can remove for cause, the president is able to take care that the law is faithfully executed because the president can resolve unfaithful execution. That is, of course, what cause is. And so 8-1, as recently as the 1980s, you had the court expanding and really doubling down on the Humphries Executor principle. And so we're talking about not just overruling Humphries Executor, overruling Morrison v. Olson, a Rehnquist opinion in the most quintessential executive activity possible. The special prosecutor was investigating the executive branch, and the court said, nope, that's okay under the Constitution.
But then in the seal of law case, the case involving the CFPB, at least when I read it and read what they had to say about Humphries Executor, they didn't exactly give it a ringing endorsement. And I became concerned at that point that this was a harbinger of something to come at a later date.
Absolutely right. So the court has been downplaying and rereading Humphries Executor for 15 years now, since the Free Enterprise versus PCAOB case in 2010, when Justice Roberts, writing for a bare majority, 5-4 majority of the court, characterized Humphries Executor as an exception to the Myers principle, which was a case 9 years earlier, 1926 case, that the president can direct, and remove principal officers of the United States, those that are nominated and confirmed by the Senate, nominated by the president and confirmed by the Senate. And so there was an attempt to recharacterize Humphries Executor in 2010. Humphries Executor was really cabining Myers to its facts and trying to reverse as much of Myers as possible. But we retell the story in 2010. Actually, this is a special exception. And then in 2020, with Saylor Law, we get what you're describing, which is a distinguishing of single director agencies like the CFPB with a lot of executive power and multi-member commissions. And Humphries Executor now only applies to multi-member commissions. And we also distinguish Morrison v. Olson. Justice Roberts tells us there are two exceptions to the Myers principle. There's Humphries Executor for multi-member commissions, and there's Morrison v. Olson, which is for single director, offices, but inferior offices, not for whole agency heads. So we're trying to figure out a way to make Morrison v. Olson not something that's in the way of overruling the CFPB. And so there's a lot of also reading out the dicta and rationale of Morrison v. Olson going on in 2010. So I think you're right to say, as of 2010, there was clear the court had it out for this. Of course, these cases are quintessential functionalism. Morrison v. Olson's functionalism, Humphries Executor's functionalism. So the court's coming in saying, we're formalists. We don't like any of this functionalist precedent, and we're going to rework this whole area of the constitutional law.
Right. The other thing I remember, though I didn't go back and read it, I intend to do it, is that there was I think a concurring opinion by Kavanaugh in Seal of Law, and Gorsuch may have joined in it, where they also said something about the Fed. I don't remember exactly what it was, but they certainly gave me the feeling that at least two members of the court thought that the Fed was different than all the other agencies. And of course, in the July 22nd ruling, they went out of their way to talk about the Fed, although they didn't say a heck of a lot other than, what you already said, that the Fed is really like the first bank and second bank in the United States. So let's segue into that area, because to me, it seems like it's almost a done deal that by the time Wilcox makes it back to the Supreme Court, if it ever does get back there, or any of these cases get up there, they are going to overrule Humphries Executor, and they're going to say quite a bit about the Fed. I think they'll say a lot more than what they said in that order, which wasn't a heck of a lot. But why don't you, I'd like to hear your thoughts on, I've been calling it the dictum in that July 22nd order.
Yeah, so that dictum was also very weird, because here's a case about the NLRB and the Merit Systems Protection Board. The Fed is not involved in the case in any way. And the court says, oh, by the way, our ruling here doesn't implicate the Fed, probably doesn't implicate the Fed. No reason to think it necessarily implicates the Fed. And this is not total, out of the blue, because I and three of my colleagues actually filed an amicus brief with the Supreme Court in this emergency application, arguing that whatever they do, they should be careful not to jeopardize Fed independence. Yeah.
Oh, so you're the reason for the dictum.
Well, I mean, I was there saying this is a really big issue you need to pay attention to. And of course, the parties in the case, Wilcox and her attorneys, were pointing out that so goes Wilcox, so goes Jay Powell. And so the court felt the need to reject that argument, to say, nope, we can put Wilcox out of her job. That doesn't necessarily mean we would support firing Powell. And so and more generally, as you said, ever since Saylor law, lurking in the background of the rise of formalism in separation of powers and the rewriting of these bedrock precedents to be exceptions was the question of what's going to happen to the Fed. And so people know that this is a problem with the unitary executive theory. And the court in May is saying, just so you know, we've decided how we're probably going to come out. We're going to have a carve out for the Fed. The problem is they really haven't figured out any principal basis for distinguishing the Fed, and in fact seem quite confused based on the sentence they offered about what the Fed even is. And so they're going to have a lot of work to do, or the clerks are, between now and the end of next term, to say something, if that's what they want to do, that makes any sense and that creates a doctrine that isn't fundamentally broken from its inception.
Right. So tell me, or tell our listeners, why it is that the reasoning they put into that July 22nd order doesn't make any sense.
Yeah. So there's a lot here that doesn't make sense, but let me focus on the big problem first. The court says the Fed is a unique quasi-private entity with a distinct historical tradition that goes to the Bank of the United States. They're obscuring the core problem that they're facing, which is the Fed is actually a bunch of different entities, which makes the Federal Reserve Act similar to many congressional statutes. Congressional statutes often implement a legislative scheme with many different entities. So the Federal Communications Act doesn't just create the Federal Communications Commission, it creates the Universal Service Fund, it creates a variety of other entities. Think about the Federal Home Loan Banks, the Federal Home Loan Bank Board, which has been superseded by the FHFA. These schemes often involve many different types of entities. And the Federal Reserve Act, its marquee entity is the Board of Governors of the Federal Reserve System. There's also the FOMC. There's also 12 different Federal Reserve Banks, which are like the Federal Home Loan Banks. They're federally chartered corporations. And the issue that the court is actually facing with respect to Jay Powell is the Board of Governors of the Federal Reserve System, those 7 principal officers of the United States that run a multi-member commission to regulate the banking system, are they covered by Humphries Executor, or are they subject to presidential at-will removal because they exercise executive power? And anybody exercising executive power does so under the unitary theory on behalf of the president. And the Constitution requires that the president be able to remove them at will in order to control their exercise of his power, of the president's power. And the court doesn't help us with that at all, because the Board of Governors of the Federal Reserve System is not unique. It is created on the model of the ICC, the FTC, the SEC. It's a multi-member commission. It has all those same characteristics. It is also not quasi-private. It's the Federal Reserve banks that are quasi-private. The board is quintessential public agency. There's nothing private about it. They are government employees. They're on the government pay scale. They've got government addresses. They're fully government officials. There's 7 fully government officials. And they don't follow the distinct historical tradition of the first Bank of the United States at all. The Federal Reserve banks do, as do the national banks in the banking system. Those are investor-owned corporations. The Federal Reserve banks are nominally owned by member banks. They're private entities, like the first bank. The thing about the Board of Governors, and this was the whole controversy about creating it, is it was a commission regulator for the banking system, for the investor-owned banking system. It was the sort of thing that the founders didn't want to do. They wanted to get the banking activity out of the government, so they created the Bank of the United States owned by private investors. And Wilson wanted to put a government board of control on top of the banking system, as did William Jennings Bryan, which is why you have the Federal Reserve Act with the Federal Reserve Board. The Federal Reserve Board follows in the distinct historical tradition of the Interstate Commerce Commission, a multi-member commission regulator, expert regulation of investor-owned enterprise, not the Bank of the United States. And so it just doesn't make a lot of sense. Let me say one other thing about it that doesn't make sense. There's nothing about the Bank of the United States precedent that shows that the founders, if we're taking sort of an originalist approach, thought that monetary policy somehow was an exception to the idea that the president has to control the exercise of executive power. Because for a formalist, the important fact about the Bank of the United States is it was not part of the government. It didn't exercise governmental power at all. So it engaged in monetary activities, it issued notes, but it was private. It's a private concern. And the court and the originalists in this debate have proffered no evidence that anybody at the founding would have thought, if the Bank of the United States were part of the government, that the president wouldn't necessarily have at-will removal power. And so this precedent isn't actually an exception. It's not like, we believed that a president who could control executive power except for monetary policy, it was okay. The Bank of the United States is no indication that it was okay because it was a private act. It was a private act.
Yeah, who owned the first bank and the second bank? Were they owned by other? Were they individuals or were they owned by, various states?
Yeah. So the first Bank of the United States was 80% owned by individuals. There were foreign investors. There were domestic wealthy investors. The biggest shareholder after the United States was eventually a man named Stephen Girard, who was one of the wealthiest men in the country, a Philadelphia merchant. Members of Congress owned shares in the Bank of the United States, and the United States government owned 20% of the shares pursuant to the act to incorporate the first Bank of the United States, to incorporate the Bank of the United States. But the government was a passive shareholder. It didn't exercise any rights as a shareholder to try to control it. In fact, ultimately sold its shares in the early 1800s. And so up through 1811, when the bank's charter expired, the first Bank of the United States was a wholly privately owned concern that resembles much more JP Morgan Chase or Bank of America today, both federally chartered corporations that have authorized to engage in banking activities, than the Board of Governors or even the Federal Reserve banks, which are very special purpose type banks with very narrow powers that can't exercise a general banking business. The first bank in the United States was just a bank. It was just JP Morgan. It did a general banking business. Ordinary people had bank accounts there. It lent all across the economy and had branches in many states. And the government's engagement with it was as its biggest customer because the government put its own deposits at the Bank of the United States. The second bank, which was chartered in 1816, a totally distinct institution, was designed a bit differently. The government got 5 of the 25 directors of the second bank pursuant to the statute, in addition to 20% of the shares. And those 5 directors were nominated by the president and could be removed by the president. And the other 20 directors were nominated by the shareholders and could be removed by the shareholders. And that bank also did a general banking business with public, huge bank, issued most of the money supply used for interstate commerce, existed across the national geography, and was also a private concern, run for profit, generated significant dividends for its shareholders. And the United States was also a big customer because it banked with the Bank of the United States, although famously in 1832, in an effort to destroy the bank, Jackson ordered the Treasury Secretary to withdraw the government's deposits and move them to other banks, state-chartered banks. And so, by the end of the second bank's life, its charter expired in 1836 because Andrew Jackson vetoed the recharter legislation. By the end of its life, it was also less integrated with the government, just like the first bank. But neither of these banks are anything like anything in the Federal Reserve System, nor were they in any way part of the government. So on a formalist theory of the Constitution, they don't actually provide any evidence that the framers thought there was some exception for banking, because they're not public banks. There's no indication that they thought if it was a publicly controlled bank, it could be for cause limits or otherwise insulated.
Yeah. So let me ask you this. And I admit I haven't read the amicus brief that you filed in the Wilcox case.
You have, I'm sure.
You caution the Supreme Court to be careful what they do here because it could have implications for the Fed. Did you give them a trail map, or did you explain to them how they could make a principled distinction between the NLRB and the Fed? Or did you make the argument that you just ought to uphold Humphries Executor and not have to deal with the Fed?
The argument that we made in this amicus brief, and there will be another one that will obviously say a lot more given how things have transpired, was just that the best way to protect the Fed and ensure that there's no adverse inferences drawn about the likelihood of the Fed to be protected, and there's no encouragement given to the president to pursue threats that were very real and continue to be very real to remove Jay Powell, is to leave Humphries Executor intact until the merit stage of this case, which seemed like the obvious path forward at this time, was just to say, we'll get to this next year. In the meantime, there's binding precedent on this question. And if you carve out the Fed and you leave it as the only agency standing, you're just inviting this battle to shift to the turf of the Fed, which is a defeat in and of itself. If we have to end up litigating the question about whether this carve out is really what it seems, the Fed is already in big trouble, as is monetary policy, as is our financial outlook, I think. So that's what we said in the amicus. My view is that there's no principled basis for exempting the Board of Governors under unitary theory. It's a formalist theory, and there's no possible way to say that a government official who's exercising executive power, as very obviously Jay Powell is, somehow doesn't fall under the theory.
And by the way, it's not just Jay Powell, it's all the members of the Board of Governors, right?
It's the other 6 governors too, yeah. They're a multi-member commission that regulates the banking system. I mean, how is the exercise of executive power with respect to banks different under the Constitution than the exercise of executive power with respect to railroads or power plants or anything? I mean, on a formalist theory, there's no way to distinguish. On a functionalist theory, of course you could distinguish, of course. But the whole point is the court is eschewing functionalism.
Right, I got it. So I guess you could say the sad story is that, if they throw out Humphries Executor and if they really take a close look at the Fed and don't rely on this first bank, second bank analog, the Fed's in trouble.
So there's 2 things. One is the court might go with a distinction that doesn't make sense anyway. And I think the Fed will be in trouble. The court, I think, is underappreciating, even right now, even after Wilcox, the extent to which Fed independence is on the line. I don't know how closely you've been following it, but there's a lot of saber rattling in the White House right now about Jay Powell. And the more the more the court rules in favor of executive power, even with this little carve-out thing here, the more the president is going to be encouraged to just push to the limit and drive Powell out of office as best he can. And this is just dangerous in my view. The second thing is I am going to try to offer the court a way to distinguish the Fed, but it's not under the theory. I think, stare decisis, I think the court can say, we don't like this Humphries Executor. We think it was wrongly decided. We believe in this formalist theory of the separation of powers, and that's how we're going to apply from here on out and we're going to apply it to every agency that's been previously created, except where you can show that Congress expressly relied on Humphries Executor and on independence in delegating powers to the agency in the first place. And it happens to be the case that basically more than any other agency that I'm aware of, when Congress gave the Board of Governors, when created the Board of Governors, which was in 1935, it was a revamp of the Federal Reserve Board, which was the initial entity. When it created the Board of Governors in 1935 and gave it way more powers over the Federal Reserve System than it had in 1913, it was expressly relying on Humphries Executor. It would not have given those powers to the president if it thought the president could exercise them directly. The Congress was expressly concerned with political insulation and partisan abuse of the Fed's powers. And Humphries Executor was decided in, I believe, May 1935. And the Banking Act of 1935, which created the Federal Reserve Board of Governors, was passed in August of 1935. And in the spring, they were fighting over creating this more powerful board. And there was reluctance because it wasn't clear whether the board's members could be removed by the president at will. Taft had decided the Myers case, and people thought that the president could. There was this 9-year period where independent agencies, it wasn't so clear that they actually had independence anymore. And that's why Roosevelt tried to fire the FTC commissioner. And as soon as Humphries Executor was decided, this impasse was resolved. And Congress took the Treasury Secretary and the Comptroller of the Currency off the Board of Governors and made it a full expert multi-member commission with removal protection. And it was relying. And so it created this powerful agency it wouldn't have otherwise created in reliance on Humphries Executor. And I'm going to try to say to the court, and I haven't really done this yet, but I plan to, that that's a way out, is just to say this is a special case of reliance by Congress. And this is true. And maybe that would lead to more arguments that other agencies there was reliance as well. And I think those are good arguments. And I think those are arguments the court ought to take really seriously.
Well, let me throw out an idea, and I don't know what you think of this, but in the Loper Bright Enterprises opinion that came down about a year ago, where the court overruled what I call the Chevron deference doctrine, they did get into the issue of stare decisis, and they talked about, because it was an issue that was of grave concern to me, because I thought if they didn't address that issue, we were going to be overwhelmed with litigation challenging very established precedent, dealing with other issues that had nothing to do with what we're talking about here. Do you think that case is helpful to you in supporting your stare decisis argument?
Somewhat. I know exactly the passages you're talking about in Loper Bright. And I think the court was absolutely right to hold in Loper Bright that the specific decisions of courts under Chevron enjoy stare decisis. Otherwise, like you said, it would lead to a radical unsettling of law, including the Chevron case itself, which construed the Clean Air Act. I found the overall stare decisis analysis in Loper Bright to be relatively weak, because I think that what the court hand-waved was the fact that since the mid-'80s, all legislation from Congress has been enacted against the backdrop of the Chevron rule of statutory interpretation. And so Congress has expressly relied on the fact that courts have said, as a form of constitutional common law, they're going to approach reviewing agency statutory interpretation in this way, or at least as a matter of APA jurisprudence. This is how they're going to do it. Congress then wrote all these statutes in which they thought ambiguity was going to be construed in favor of the agency. And the court did not point this out. It didn't address this, that everything post mid-'80s, there's a presumption that Congress wrote the statute to give the agency that, and now you're saying you have a different rule of interpreting all those statutes?
Yeah, I got it. So I take it you've got some other Supreme Court precedents that will hopefully be
But
more
the whole doctrine of stare decisis, I think, wasn't like fully appropriately applied in Loper Bright. But there are dozens of examples of stare decisis analysis, all of which I think suggest that you need a really hard bar to overrule. The whole legitimacy of the court in the constitutional system comes from the fact that it has to stand by things decided. Only a legislature can chart a new course. A legislature elected by the people, elected body. Unelected bodies are stuck with resolving new disputes. If there's a need to chart a new course, that is for the elected bodies, not for the unelected body. And one thing that this court is jeopardizing is its own legitimacy by taking new courses in that way. You can disagree with prior results, but if you're a judicial official, you are bound to follow them. That is the nature of adjudicatory work. That is the nature of being a judge. You're not a legislator. And I think it's high time this court recognize that and say forthrightly, we would have done this differently. But we're a court, and we don't get to change the law in the way a legislature
does. Let's talk, and we just got a little bit of time left, but what has happened after, was it May 22nd, when the order came down? Have there been additional developments in the lower courts at Wilcox or any of the other lawsuits that have been filed? I believe that the federal trade, the challenges that were, or the lawsuit brought by the two commissioners of Democrat commissioners, the FTC, who were terminated, I think they didn't seek any kind of preliminary injunctive relief. I think they went right to summary judgment, if I'm not mistaken. I don't think
there have been some developments in some of the other cases, but no material developments. The way this is on track for is a DC Circuit en banc ruling one way or the other, followed by certiorari, followed by oral argument in the fall. Bedoya, one of the terminated FTC commissioners, he wants to pursue other work since he's out of a job right now. And so he's no longer pursuing injunctive relief, which would require him not to pursue other work. He's just pursuing back pay. And so that case isn't dead. It's just, he will not, even if he prevails, and if Wilcox prevails, he's not going to go back on the FTC. It's over. And so for people who are following who's going to be on the FTC or not, that's a significant change in the posture of that case. Trump has driven Bedoya out of the FTC. But for this legal issue more generally, those sorts of developments aren't super important because basically it's almost certainly going to be the Wilcox dispute that reaches the court on the merits.
Right. Yeah, that's the one. Yeah. Okay. So now I guess it's conceivable. Well, no, that case is actually will go up there. But what I'm saying is this whole Fed issue that we've been talking about, once Jay Powell's term as chair expires, I think in May of next year, well, he's still, am I right, Lev, that although his term as chair expires, he will continue as a member of the Board of Governors?
He could. So in recent history, when chairs have had their terms expire, they have resigned if their governor term is longer, which it almost always is. And so he could resign or he could stay on, which Mariner Eccles did to spite the president, basically 70 years ago or so. And so, yeah, I don't think we know. I mean, if Powell has said anything about his intentions, I didn't see it.
And then there's also the possibility that Trump might try to fire Jay Powell for cause. He seems to be doing a lot of saber rattling right now about renovations that Powell authorized at the Federal Reserve Board, converting it into a palace of some type. I'm being facetious, but I think that's basically...
You're accurately characterizing what they're saying. Yes, I think that the administration is actively seeding the ground for a possible for-cause removal of Jay Powell. And they've tried out in public a number of possible arguments, I think, in an effort like trial balloons to see what might stick best. All of them are obviously completely contrived, but that doesn't mean that pursuing that wouldn't prevail in court. We haven't had a presidential for-cause removal in over 100 years. And there's just not a lot of law, period, on how strict of a standard the courts would apply in reviewing a presidential for-cause determination. There is procedural strictures that I think are fairly clear, although nobody thinks about them. Notice and a hearing is required, in my opinion. And so if President Trump doesn't give notice and a hearing, I think the court can kick it immediately out on procedural grounds. But if he gives notice and a hearing to Jay Powell, and then Powell goes to court and says, on these facts, cause isn't met, boy, I wonder whether this Supreme Court would be willing to say that second guess the president's adjudicatory determinations, factual determinations on in a cause proceeding. So I think that is a big issue out there that nobody's talking about, but that is looming as well. That is somewhat orthogonal to the whole Wilcox.
Yeah, I think. I mean, here's my prediction. I may be wrong, but he's now beginning to, and he has said that he's going to. He's vetting candidates now to replace Powell as chair. He's mentioned Scott Bessent, who's the Secretary of the Treasury. If you go on, I think it's called Polymarket, that gives odds on things that might happen. He's 15% favored to replace Powell. And I'm wondering if what he will do is indicate fairly soon who he wants as the successor, see how that plays out on Wall Street. And if Wall Street is comfortable with that, then at that point, fire Powell for cause and litigate the issue.
I think that's as good a prediction as any I've heard.
Right. Okay. We're going to wrap things up now, Lev. Do you have before we sign off, anything that we should have covered that's germane to the subject that you want to mention?
No, I mean, of course, we could talk for another hour, but I think we really covered a lot of the highlights, and it was a good conversation.
Yeah, I do too. Well, thank you very much for being part of our podcast show today. And we'll have to revisit this issue in a few months and see if it is worth doing a follow-up podcast. So thanks a lot, Lev, for taking the time and being on our show.
Thank you for having me. It was a lot of fun. Yeah.
And to our listeners on our podcast, to make sure you don't miss any of our future episodes, you can subscribe to your show on your favorite podcast platform, be that Apple Podcasts, YouTube, Spotify, or wherever you listen. Don't forget to check out our blog, also consumerfinancemonitor.com, for daily insights on the financial services industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, podcast@ballardsvar.com. Stay tuned each Thursday for a new episode of our show. Thank you very much for listening, and have a good day.